Well, welcome to the Sino-American Exchange, Topics in Juvenile Justice Reform. My name is John Kamm. I am the Executive Director of the Dui Hua Foundation. I would first of all like to thank the presenters from China and the United States, as well as the staff of Dui Hua and the research department of the Supreme People's Court, under the direction of my old friend, Deputy Director General Jiang Jihai, for the hard work that went into making this exchange possible. I am especially grateful to Ellen for her great contribution to the success of this program. This is the 9th cooperative program on juvenile justice, including programs on women in prison and girls in conflict with the law, involving Dui Hua and the Supreme People's Court. It is the 7th program dedicated exclusively to juvenile justice. These programs have been held virtually and in person. We have overcome many difficulties and have emerged successful. People sometimes forget that the rights of juvenile offenders are human rights. Children's rights are juvenile rights, are human rights. In fact, they are among the most important human rights. In fact, they are. Juveniles represent our futures and the leaders of all countries, inside and outside of government and judicial circles. We have an obligation to protect and nurture them. The emphasis should always be on rehabilitation and not punishment. After my brief remarks, I will give the floor to Deputy Director General Jiang Jihai, who will deliver welcoming remarks. Following Judge Jiang's remarks, Judge Len Edwards will introduce the American presenters. Deputy Director Jiang, the floor is yours.
尊敬的康源主席，爱德华兹法官
Honorable Executive Director John Kamm, Judge Edwards, dear American friends, Ms. Liu Anqi of the Communist Youth League of China, colleagues of International Cooperation Department of SPC, and judges of the Sichuan Provincial High People's Court, and judges from Beijing Internet Court. Good morning and good evening, everyone. I'm very delighted to meet all of you online again to discuss and exchange issues regarding juvenile justice. For many years, China and the United States have conducted exchanges and collaboration on a wide range of issues, including economic, cultural, and justice. Since 2008, the two sides have maintained close exchanges in the field of juvenile justice. In the past more than a decade, the two sides have conducted 7 programs, 7 exchanges with a lot of fruits and achievements. The judges of the two countries have established enhanced friendship. Therefore, those exchanges have played an important role in promoting our cooperation exchanges. Here, I'd like to express my heartfelt gratitude to the judges who have supported these projects and friends from the Dui Hua Foundation from the US. Thank you so much. As we know, minors represent the future of a country and the hope of a nation. The Chinese President Xi Jinping have always given particular caring for the health, safety, and happy growth of the minors. He once stressed that it is a great wish that children can grow up better. It is a strategic mission of the country to better educate children, which is related to the long-term mission of the whole country. The Chinese courts have always attached great importance to juvenile justice over a long time, where the Chinese courts have continued to explore the reform of the juvenile justice and constantly try to improve the juvenile justice we try to make contribution to protect the legitimate rights and the interests of minors, try to do a better job in correcting and prevention of juvenile delinquency. That's making our contribution to the health growth of Chinese minors. China's newly amended law on the protection of minors clearly provides that the protection of minors must be based on the principle that is the most beneficial to the minors. That should be the fundamental principles on the basis of the past 4 protections by the families, schools, societies, and the judicial system. We also have added the internet-based protection and the governmental protection, therefore have put in place a 6-in-1 comprehensive protective system. So we have promoted the continuous improvement development of the mechanism of minors protection. Taking the newly added internet-based protection as an example, my colleague Judge soon will elaborate on that. So the protection of minors also have been focused on the internet literacy protection, education, internet information, and content management, and the prevention of the addiction in internet. So the Chinese courts have increased our crackdown on the use of internet to commit crimes or infringement against the lawful rights of the minors, striving to create a very healthy cyberspace for the healthy growth of minors. On January 1st, 2022, China's Family Education Promotion Law was officially implemented, entered into force. So the family education have been elevated from the family affairs to state affairs, which provides that parents certainly shall bear the major responsibility for the education, but that's a comprehensive duty, and responsibility is also a statutory responsibility. If the parents fail to fulfill their duty or the responsibility of family education, they shall be held legally accountable. So in handling the cases, if the courts identify some serious criminal conduct or other misconduct by the minors, or the parents or other guardians of the minors improperly exercise the family education, which actually infringe upon the lawful rights and interests of minors, then the court can issue the family education orders according to specific regulations, which basically order the parents to accept family education guidance, which is mandatory. In 2022, Chinese courts strictly implemented or enforced the Family Education Protection Promotion Law. Based on the law, the courts issue more than 10,308 family education orders in accordance with the law, and we have conducted more than 38,080 family education guidance. In the meantime, China's courts alone or jointly with relevant government agencies established 887 family education guidance institutions and actively exploit professional and standardized family education guidance mechanism with remarkable achievements. So when it comes to the building of the social support system for protection of minors, my colleagues from the Central Committee of the Communist Youth League will give you a more detailed introduction. The Chinese courts will give full play to the role of 12 functions, strengthen cooperation with social organizations, and promote the continuous improvement of the social support system for the judicial protection of minors. Also, Chinese court will also rely upon our extensive case docket, focus on the common problems and governance difficulties based on the previous cases, and put forward the relevant judicial suggestions to other government agents so as to promote the perfection of the Chinese social governance system. We're very happy to share with our American colleagues the latest development achievements of juvenile justice here in China. Also, we're keenly looking forward to sharing your best practice and experiences. I hope that everyone can be very forthcoming in your presentation, so we can have a very warm discussion and brainstorming, so we can work together to contribute our wisdom to the further innovation development of juvenile justice in China and the United States. I wish this online seminar, a webinar, a complete success. Thank you so much, Executive Director John Kamm. Thank you.
Thank you, Judge Jiang. Judge Len Edwards, retired, is known around the world for his expertise and experience in juvenile justice. A retired judge who served for 26 years on the Santa Clara Superior Court. He is a veteran of American exchanges with China's Supreme People's Court. He will present on recent developments in the sealing of juvenile records, an area of special expertise. He will introduce the other American presenters. Judge Edwards, the floor is yours.
Thank you, John Kamm, and thank you, Judge Jiang. It is an honor to participate once again in an exchange of ideas between colleagues in the United States and in China. We all share the same goals. We want our young people to have full lives, that their potential will be reached, that if they should stray, there will be rehabilitation. I am now going to present my talk on record sealing. The juvenile justice system was created to offer youths an opportunity to rehabilitate so they could become productive members of society. Those who created the Juvenile Court realized that children are developing beings and should be treated differently from adults. While one purpose of the juvenile law is to hold law violators accountable for their actions, the primary goal of the juvenile justice system is rehabilitation. As the California Attorney General's office stated, this section has been called a clear statement of the legislative policy to grant the errant juvenile a clean slate if he grows into a law-abiding adult. Our legal system understands that children make mistakes in their youth that they will not make in adult life. In fact, studies indicate that the youths who violate the law will likely refrain from delinquent behavior after contact with the juvenile justice system. After a youth has had contact with the juvenile justice system, it is difficult to start adult life with a clean slate. The principal problem is records of that contact, which will follow the youth indefinitely. These records have the potential for harmful consequences well into adulthood. The records are held by juvenile court, justice agencies, educational institutions, and businesses where a crime may have been committed. These records may lead others to deny the young person access to opportunities. When I spoke to the Chinese judges who visited California many years ago, I identified several problems that prevented record sealing from being effective. In the ensuing years, many of these problems have been overcome, but several remain. First, I pointed out that the system of petitioning the court to have a record sealed did not work. Very few people took advantage of this opportunity. They either do not know that they have a record, are not advised that they have a record, and even if advised, they forget about having a record or believe that whatever record they have will not have an impact on their life. They also may not have the time and or the resources to take action. Second, I mentioned that almost anyone who makes the effort can obtain another person's juvenile record. Employers, credit reporting agencies, educational institutions, insurance companies, newspaper reporters, and social service agencies are known to use investigators and private companies to discover juvenile records. The use of insiders at law enforcement agencies or probation departments has long been an effective means of gaining access to otherwise confidential information. Third, it is not known whether all agencies actually seal their records after they receive an order from the court. For example, the Federal Bureau of Investigation will not acknowledge that they seal records even when presented with a court order to do so. Fourth, even after a record has been sealed, the person is not protected. The potential employer may ask the person, "Have you ever had your record sealed? If you lie to me, you will be immediately fired." Even though the law may protect the applicant who denies having a record, the person will often be intimidated and reveal information about even a sealed record. Our solutions. Our California legislature created new laws in the past few years. Perhaps the most important is one that automatically seals all records upon completion of court proceedings. It is contained in Welfare and Institutions Code Section 786. This legislation covers all types of juvenile justice records except for very serious crimes. Only a judge can seal those records after a hearing at which the prosecutor can be present. What about cases that never reach the juvenile court? Most cases are resolved with a warning or with some informal services provided by the probation department. Nevertheless, these cases have records held either with law enforcement or with the probation department. And a record of any law violation may be sufficient to persuade an employer or other authority to deny an applicant access. The answer from our legislature was to pass a law requiring the probation department to send notifications to law enforcement and other entities holding records to seal them. This statute mandates sealing of records for cases that never reached the juvenile court. This was codified in our Welfare and Institutions Code, Section 786.5. What about the potential employer or school who asks an applicant if they have a record? Our legislature passed a law that prohibits asking if an applicant has a juvenile record. The penalty is a fine and recovery of attorney's fees. Our remaining problems. We are not certain which justice agencies have copies of records created by the juvenile court or law enforcement. To seal all records completely, court orders to seal records must be transmitted to all agencies holding such records. We have discovered that some justice agencies are not following court orders to seal records in a timely manner. The California Department of Justice has thousands of court orders to seal records that they have not yet followed, some for over 2 years. These delays have put many young adults at risk of having opportunities for employment, higher education, applications for licensure, and other paths to successful adulthood at risk. The problem seems to be a lack of personnel to follow court orders. The juvenile court judges in California are meeting with the Department of Justice to address this issue. Summary. I believe that lawmakers should appoint an ombudsperson to oversee the record sealing process. This person should have sufficient staff to visit law enforcement and probation offices throughout the state or country and check to see that records are timely sealed. The ombudsperson will have to have a staff to complete the oversight process. Once the ombudsperson's office has confidence that the holders of records are are sealing those records in a timely fashion, the office could be reduced in size or possibly ended. I also believe that the Ombuds office should go to employers, schools, the armed forces, and other organizations and test the application process. Check to see if applicants are required to reveal records, either on forms or in response to questions. We have had to check to see if potential employers are following the law and not asking about juvenile records. But this is an enormous task. The Ombudsperson's office should be charged with monitoring the record sealing process. If we are serious about record sealing, we have to be much more aggressive than we have previously been. We need to look closely to see if the law is being followed. Our judges did not know whether their sealing orders were being followed in a timely fashion. We only learned about these failures when court clerks complained that they were not receiving compliance confirmation from the Department of Justice. We believe that our youth deserve a fair opportunity to be rehabilitated when they reach adulthood. Ensuring that their juvenile records are sealed and destroyed is an important first step to ensure that they will have that opportunity. It is now my honor to turn the microphone over to my colleague, Judge Mike Nash from Los Angeles. Judge Nash became a judge back in the 1980s. He has served in the Juvenile Court as a judge, and then in the Superior Court Juvenile Division, where he was the presiding judge for 14 years. Rather than retire, he is now the head of the Los Angeles Office of Child Protection. I give you Judge Mike Nash.
Thank you, Judge Edwards, and good evening, everybody, and good morning, everybody. It's an honor to be here with you for this webinar. You know, when children are removed from their homes as a result of child abuse and/or neglect, the child welfare system in our country has a variety of options for their placement. These options include placement with a previously non-custodial parent, placement with a relative, placement with a non-relative who is close to the child, commonly known as a non-related extended family member, placement in a foster home with a resource or foster family, or placement in a congregate care setting. At this time, I'm going to talk about congregate care. Congregate care settings include group homes, temporary shelter care facilities, orphanages, or other private institutions. While congregate care may be appropriate in some instances, it is generally regarded as the least favorable placement option for children and youth. Various studies have affirmed the notion that children are better served being raised in a family setting. Further, outcomes for youth in congregate care settings are too often less than satisfactory. Some of the negative outcomes for children and youth in congregate care can include, first, a higher proportion of children and youth in congregate care age out of foster care or extended foster care without achieving permanency, which is actually a fundamental goal of our child welfare system. Second, a higher proportion of youth in congregate care cross over from the child welfare system to the juvenile justice system. Third, a higher proportion of youth in congregate care are prescribed and administered psychotropic medications. Fourth, a higher proportion of youth in congregate care are targeted by and become victims of commercial sexual exploitation. Fifth, African American youth are disproportionately placed in congregate care. Sixth, a higher proportion of youth in congregate care obtain significantly lower levels of academic achievement. 7, a higher proportion of youth in congregate care become involved with drugs. 8th, and very importantly, a recently published study followed over 160,000 children who were placed in non-parental care, and were followed for 30 years. The study concluded that over their lifetimes, these children are more likely to have poorer physical and mental health outcomes and die sooner than those children who remained at home or were placed with relatives. And last, the cost to taxpayers is significantly higher for a child in congregate care compared to a child who is placed in a family setting. As a result of these negative outcomes, laws at both the federal and state levels have been enacted to limit and improve the use of congregate care and to enhance court oversight of children and youth placed in congregate care. Perhaps the most significant federal legislation is the recently passed Family First Prevention Services Act, also known as FFPSA here in the States. The components of this legislation relating to congregate care include limiting congregate care to cases where adequate services cannot be safely provided in a family setting, limiting the amount of time a child or youth can stay in congregate care to the minimum time required for stabilization of the youth, requiring a trauma-informed treatment model to meet the identified needs of the youth, requiring a provision of on-site nursing and clinical staff who are licensed and available 24 hours a day and 7 days a week. There's also a requirement for the need to work with families in treatment as appropriate. And also there's a requirement of discharge planning and a minimum of 6 months of family-based aftercare services. Lastly, there is a requirement of court oversight. Juvenile court judges here in America are responsible for overseeing the safety and well-being of all children and youth under juvenile court jurisdiction. This oversight responsibility is particularly important for children placed in a congregate care setting. The National Council of Juvenile and Family Court Judges, also known as NCJ-FCJ, is the nation's oldest judicial organization consisting of some 2,000 members. NCJ-FCJ advocates for policies in support of children and families at risk and also conducts trainings for thousands of juvenile and family court judges every year. In 2016, NCJ-FCJ adopted a resolution regarding judicial oversight of children under court jurisdiction in group facilities, in which the organization recommends that because of the increased vulnerability of children placed in congregate care, judges should be apprised of and continually updated on the following information. First, they need to know the need for congregate care rather than a family setting. Secondly, why a particular congregate care facility was selected. Third, what is the child's specific comprehensive case plan and goals, including the timeline for moving the child to a more family-like setting. If a child is receiving psychotropic medications, the names and qualifications of the prescription prescribing the medications and the names of those responsible for administering the medications and monitoring their effects. Fifth, child's school status, including whether a school change is necessary, whether the child is enrolled in school, whether school records have been transferred, and whether special services will be continued or offered. Sixth, the impact on other services the child is receiving and whether additional or new services will be offered. Seventh, what efforts are being made to engage the child's family or future caregiver in the treatment program. Eighth, the judge needs to know what is the impact on family reunification, permanency, and family visitation, including visitation with siblings or contact with siblings. And last, the judge needs to know on a regular basis what progress is being made toward the implementation of the case plan. Now, there's a publication known as the Imprint, which is dedicated to news coverage of the child welfare and juvenile justice systems. It has a project entitled, Who Cares? A National Count of Foster Homes and Families. Who Cares compiles federal and state data on a variety of issues, including the use of congregate care. According to Who Cares, the use of congregate care declined significantly from 2011 to 2020. In 2011, there were 30,743 children and youth in congregate care and 20,722 in 2020. This decrease is reflected in all but a few of our 50 states in the United States. But, despite the overall decrease in the number of children and youth in congregate care, there is still a wide variation among states and within states in the percentage of children in out-of-home care who are in congregate care. In addition, while research reflects that children who need specialized residential treatment should not be there longer than 3 to 6 months, the United States Department of Health and Human Services data shows children in congregate care average 8 to 9 months or longer. The good news is that the use of congregate care is on the decline, but there is still more that needs to be done to reduce its use. While congregate care will probably always be necessary for some children in certain situations, it should be a short-term, intensive intervention with a goal of moving the child to a more family-like setting. A congregate care treatment program should endeavor to involve family and ultimately help youth heal and learn skills for managing their emotions and behaviors that will enable them to have more healthy and productive lives. Thank you.
Thank you, Judge Nash. And now our next presenter is Jean Roland. Jean is a prosecutor in the San Francisco County District Attorney's Office, where she has served for 22 years. She is now the supervising judge of the Juvenile Division. And in that role, she participates in the prosecution of juveniles for breaking the law. Ms. Roland, you're on.
Thank you, Judge Edwards. I'm honored to be here and honored to be invited to speak on this panel for such an important topic. I'm going to share my screen with you. So I will be presenting on the role of the juvenile prosecutor. So when we think about the role of the juvenile prosecutor, one of the first questions that we will look at is, hold on one second. So when we look at who is the juvenile prosecutor is part of the district attorney's office, and typically it is a separate unit and often in a separate courthouse. We have jurisdiction over cases involving acts that would constitute a crime if the youth is an adult. And the crimes are committed when the young person was 12 to 17 years old at the time of the offense. So according to the National District Attorneys Association, the prosecutor's office should devote specific personnel and resources to fulfill its responsibilities with respect to juvenile delinquency proceedings, and all prosecutors' offices should have an identified juvenile unit or attorney responsible for representing the state in juvenile matters. For smaller and or rural jurisdictions, it is appropriate to combine resources when possible to do so. So after a case is presented to the district attorney's office, there are 3 possible outcomes. We can file formal charges, we can send the case to diversion, or we can discharge the case. We can file formal charges and allow the case to be processed in a traditional court setting. The youth may be detained pending conclusion of the case or released in the community, often with conditions. For diversion, in lieu of filing a formal charge, we can refer the case to a diversion program. And the factors that are considered for that is the seriousness of the offense, the victim input, and amenability to pre-filing interventions. For discharging a case, if there is insufficient evidence to bring the charges, we can discharge the case completely, or we can discharge the case and request law enforcement to conduct further investigation so that we can file charges later. So the National District Attorneys Association Juvenile Prosecutor Standards, this is the charging and diversion criteria that we follow. In determining whether to file formally or divert, the prosecutor should consider these factors: the seriousness of the offense, for example, whether the conduct involved violence or bodily injury to others, the youth's role in that offense, the nature and number of previous cases against the juvenile and the disposition of those cases, the youth's age, maturity, and mental status, the existence of appropriate treatment and services through the court, child welfare services, or prior diversion, whether the youth accepts responsibility for the conduct, community safety, the decision made with respect to similarly situated juveniles, and recommendations of the referring agency, victim, law enforcement, and advocates for the juvenile in consideration of the youth's rehabilitative potential. So here is an example of a pre-filing diversion program. So when we look at this chart, you can see that when there is a harm that occurs, the youth is arrested. And then when you look at the youth being arrested, the case can actually be diverted at that point by the police department, which is law enforcement, to a community-based organization. If it is not, then it'll go to the probation department. When the case goes to the probation department has the ability to then send the case to a community-based organization, or it will be sent to the district attorney's office. So when we get the case at the district attorney's office, then I would review the case and then determine whether or not we will file charges. If we file charges, this will be a traditional route where we would go to court, we would do pretrial conferences, and then when there is a resolution, the youth will be sentenced. And at that point, the youth can be on probation with other sanctions, or it will go to a detention facility. And after, we are looking at the potential of an ongoing cycle of incarceration. When the case is diverted to a program, we follow the other route where it would go to a community-based organization. The responsible youth would agree to this process. The person harmed, who is the victim, would also agree to this process. they would actually go to a restorative community conferencing process where they would sit down together. And then they would come up with a plan. The plan would then be completed, and there would be no charges filed at that point. And hopefully, this would disrupt the cycle of incarceration. So that is an example of our diversion program. When we're looking at ensuring system accountability, the prosecutor should periodically review diversion and dispositional programs, both within and outside the prosecutor's office, to ensure that they provide appropriate supervision, treatment, restitution requirements, or services for the juvenile. The prosecutor should maintain a working relationship with all outside agencies providing diversion and dispositional services to ensure that the prosecutor's decisions are consistent and appropriate. If the prosecutor discovers that a juvenile or class of juveniles is not receiving the care and treatment envisioned in disposition or diversion decisions, the prosecutor should inform the court of this fact. Under the Welfare and Institutions Code, which is the law that we follow here, juvenile courts and other public agencies charged with enforcing, interpreting, and administering the juvenile court law shall consider the safety and protection of the public, the importance of redressing injuries to victims, and the best interests of the minor in all deliberations pursuant to this chapter. Participants in the juvenile justice system shall hold themselves accountable for all its results. They shall act in conformity with the comprehensive set of objectives established to improve system performance in a vigorous and ongoing manner. Thank you. And that is my presentation. If you have any questions, please feel free to reach out to me, and this is my email address. And I will now turn it back to Judge Edwards.
Thank you, Ms. Roland. And now it is my pleasure once again to turn this matter over to Judge Jiang, who will introduce the presenters from China. Judge Jiang.
非常感谢美国同仁的精彩的发言，你们的发言对
I
我
want
们
to thank US colleagues' very insightful presentations. I think your participation have been very useful, conducive to us, to our understanding of the most important topics like the sitting of the records, the role of the prosecutors, and other topics. So let me introduce the Chinese speakers. The first one is Sun Mingxi from the Beijing Internet Court, discharge. The second speaker is Judge Fan Yu from High People's Court of Sichuan Province, who's also the in charge of the Juvenile Justice. Next one is Liu Yanqi, who's from the Chinese Communist Youth League, whose office of Juvenile Rights and Interest Department. So firstly, give the floor to Judge Sun.
美国的法官专家，大家上午好，以及各位中国的同仁，大家上午好。很荣幸的能在这里向大家介绍北京互联网法院在未成年
greetings to the Chinese colleagues and President Kamm, and greetings to all of you, US colleagues, judges, and experts. So I'm so happy to speak on behalf of Beijing Internet Court and report to you the protection of juvenile rights and interests of the minors in cyberspace. Now, cybers are living in the digital society with in-depth integration of online and offline space. In 2020, there have been 191 million minor internet users, and the internet penetration in them has reached 96.8%. In China, internet is profoundly impacting their way of life, study, and communication. BIC, Beijing Juvenile Court, has been endeavoring to protect their rights in the following ways. The first is to adapt to the development of the digital era and leverage information technology to modernize trials involving the minors. My court, BIC, is a primary people's court with a centralized jurisdiction over civil disputes relating to the internet in Beijing. Since its inception in 2018, we have inaugurated the full process e-litigation platform, which enables the online processing of case filing, mediation, trial, and enforcement, bringing great conveniences to all the litigants, including the minors. Disputes involving minors accepted in my court may include the cases of online shopping, online game recharging, tipping live streamers, online verbal infringement of personality rights. In 2021, a division was designated to collectively hear the cases involving the minors to better protect the legitimate rights and interests of the minors. We explored a series of working mechanisms that prioritizes minor protection. For example, for cases involving the minors, we give priority to mediation. We invite professionals who understand both the law and the work of the minors to join the team of mediators, so that many cases involving minors can be efficiently resolved without going through the formal trial process. So far, up to 77.5% of the cases involving the minors and accepted by BIC have been concluded by mediation or voluntary settlement. We have also developed online chat rooms for cases involving the minors. Through virtual imaging technology, we transformed the traditional layout of courtrooms and adopted green, white, and other relaxing and bright colors, which can fully alleviate the tension and anxiety the minors may have. It is widely applied to mediation and other non-litigation procedures involving the minors, and very much acclaimed by the minors and their parents. Second, we uphold the principle of the best interests of the minors and respond to new issues in minors' protection in cyberspace. In the digital era, the protection of the minors in cyberspace has attracted wider attention. In 2020, China amended the law on the protection of minors, adding a special chapter on internet protection to improve the system of internet protection for minors in aspects of internet literacy, education, online information content management, prevention and treatment of internet addiction, personal information protection, and prevention and treatment of the cyberbullying, as mentioned by Mr. Jiang. Relevant departments also issued regulation on the online protection of children's personal information and documents relating to online gaming, online streaming, which have also played an essential role in protecting the minors' personal information and preventing them from internet addiction. We also value the role of judicial adjudication to reinforce the consensus of whole society on protecting the minors in cyberspace. We have also paid attention to the new characteristics of the behavioral patterns in the digital era and effectively regulate the behavior of minors involving the recharging and the tipping streamers in large amounts. While the physical and the mental characteristics of the minors determine that they tend to have greater passion and ability to accept online information and acquire network skills, it is also more difficult for them to resist the temptation of the internet and give rise to internet addiction. While handling many cases involving their popping up and the tipping cases, we found that many minors, unknown to their guardians, used the accounts of their elder adult family members or purchase accounts of adults to top up or tip the streamers, invading the anti-addiction system of online products. This makes it difficult for us to ascertain whether the online consumption is actually made by the minors or not. Accordingly, BIC has formulated the guidelines for court investigation to find facts as far as possible by identifying the contents followed by or published by the account, the content, period, and the frequency of consumption, and the IP addresses of the user and other objective elements. Meanwhile, BIC also actively communicates with the gaming platforms and the live streaming platforms and gives priority to mediation to help the minors recover their losses. 93% of such cases were concluded by mediation. We have been paying attention to emerging risks in the internet sector and strengthen the protection of the minors' personality interests in cyberspace. in the era of we media, everyone is a mouthpiece, and the trending events of the minors are even more eye-catching. In a case of infringement on a minor's right of personality heard by my court, the parents of the plaintiff, a little girl, were criticizing and educating their daughter on a public occasion because a little girl was naughty or disobedient. The defendant happened to pass by. He recorded this and uploaded the video onto the internet with original intention to expose the parents' inappropriate way of parenting. The video, which clearly showed the girl's face and the relatively private parts of the body, were widely shared by numerous citizens, internet users, after uploading. So while hearing this case, we explicitly put the minor first and as our value orientation and held that in public events involving the minors, despite good faith, the physical and mental characteristics of minors shall be fully considered and the rights to image, privacy, and rights be protected, thus delineating the boundary of the oversight through public opinion on the trending events involving the minors. We also send judicial recommendation to the relevant social media platform, suggesting it to strengthen the review of the content involving the minors and promptly accept and deal with the relevant complaints and reports. The social media platform actively improved their functions accordingly. We have also been paying attention to new developments of cyber culture to strengthen the content management of cultural products for minors. The target audience of such products are extensive. In the vast amount of content online, how to coordinate the common cultural needs of the general internet users with the physical and mental health of the minors is a difficulty of online content management. In the case of talking about the 4 softcore pornographic cartoons tried by my court, the minor litigant paid to view cartoon online for a long time. Through the investigation we have made, we found that most of the cartoons on the platform were themed on campus life, which appeals to minor readers. However, the cartoons are also full of the softcore pornographic elements and other content that affect the physical and the mental well-being of minors without giving reasonable notice or restriction. BIC held that the content unsuitable for minors in the cartoons were against the public order and good morals, and there were not any clear notices or restrictions, and actively urged the cartoon platform to intensify content management. We have also paid attention to online verbal anonymity for adolescents and to purify the cyberspace. Through many cases involving online infringement on the right of reputation, we found that in the wake of the flourishing of the entertainment industry and boom of the so-called fan culture, it is not rare to see adolescents committing infringement on the right of reputation, usually by muscling public figures so that their fans, and even using a mass of argos in the fan groups. The minors involved in such cases have little awareness, and most of them believe in their fluke mind that the virtual nature would free the internet from the accountability. When hearing such cases, we set up the education and guidance and make the minors understand that cyberspace is not beyond the law. In addition, we also reflect on this case and probe into the root cause of the verbal anomalies of the minors by taking the case's infringement on the right of reputation as a samples of research and publish the research report on the fan culture and the online verbal anomaly of the adolescents, which offered a solution and recommendations in response. Third, we actively carry out internet literacy education and gather synergy for the protection of minors. The growth of the minors is vital to family happiness, national development, and social stability. The protection of the minors needs the joint forces of the whole society. In addition to adjudication, we also actively extend the protection of minors. We focus on improving the internet literacy of families. As Mr. Jiang said, the law on family education promotion enforced in 2022 is considered an indispensable litigation for bringing up children in accordance with the law. While hearing cases, we found that minors are addicted to internet because their parents' lack of internet literacy and improper supervision and guardianship. Therefore, we launched a family education guidance platform on our official website. On one hand, the judges can provide a family education guidance for parents and other guardians, as well as minors through online conversations. On the other hand, the judges can request the parents or other guardians to attend the relevant courses online and provide feedback in due course. Additionally, the platform is also open to general public with professional courses available anytime, anywhere. In the case of a minor topping up and the tipping live streamers, the parents of the minor receive the first online family education instruction order. The parents, guided by the judge, logged onto the family education guidance platform and attended online learning for a certain period of time. The courses which help the parents enhance the awareness of protecting their own payment account and use the children's behavior, and that has been well received by the parents. We also assist the schools in internet literacy and rule of law education for the minors. We select a number of vice presidents of the schools for the rule of law who are adept in the work relating to the minors. The judges also brought legal knowledge to schools and offered courses on the rule of law for students. We also opened the court to the visitors. We invited more than 100 primary and secondary school students to experience the leading edge of the internet justice and engage in internet legal education. We also produce short videos and comic books to promote the law, which focus on the hotspot issues in the protection of minors in cyberspace and promote the popularization of law. Dear guests, we are entering the metaverse, which deeper integrates the virtuality and reality in the new era. Protecting the safety of the minors in cyberspace is a common task of the entire world. The BIC will actively adhere to the principle of the best interests of the minors and spare no efforts to set up rules through the cases and advance governance through rules to foster a safe, healthy, and clean cyberspace for the children. Thank you so much, Judge Sun. I would like to now invite Madame Fan Yu, the Vice Director of the Criminal Law Department of the Sichuan High Court. So good morning to the Chinese colleagues and good evening to the US colleagues. So I'm going to share with you Sichuan province practice regarding family education guidance system in criminal trials. Currently, prominent issues on the floors of family education has been reflected in criminal cases involving minors with the official implementation of the law on family education promotion on January 1st, 2022, which is the first specialized litigation of family education in China. Family education is no longer just a private matter. Based on the special and prioritized the protection of the minors in accordance with the principle of the state exercising parental right, the legislation has established a system of family education guidance, providing a legal basis for the judicial intervention. From the beginning of this year, the day when the law took effect to December of the same year, a total of 1,286 family education orders issued. We also tried different means to develop the locally different but also commonly applicable practices. So we have been developing a common education guidance system involving the families, schools, and communities, and promoted the regulated and orderly application of the law and the guidance. First, we clarify the targets and the content of family education guidance for defendants that are minors. It is explicitly stated that the judges must initiate family education guidance, and a tiered treatment mechanism should be applied depending on whether the minor defendant is detained, and different educational guidance will be provided accordingly. For victims who are minors, it is explicitly stated that the judges may initiate family education guidance, but in cases of sexual assault or where the victim is left behind the child of migrant parents, the guidance must be initiated. A unified name for the family education is also explored.
So there are two modes of family guidance. So firstly, parents or other guardians are required to receive educational guidance from relevant personnel at a designated time and place. Well, secondly, written guidance is provided to parents or other guardians in the form of a document that specifies the guidance content. So the relevant orders and documents issued by the courts are collectively called family education orders. Well, secondly, the content of family education guidance documents shall be standardized by clarifying the objects who are required to receive guidance, the time and place to receive guidance, and the legal consequences for failure to attend on time, providing negative evaluations on inappropriate family education conducts, listing the specific content and methods for correcting such behaviors, and clarifying deadlines for enforcement, remedies for non-compliance, and legal liabilities for refusal to comply, etc. This has improved the to the pointedness and effectiveness of family education guidance. Well, secondly, we have explored the 3-in-1 trial mechanism to avoid the concentration of family education guidance on one-way communication from judges and the kind of lone wolf approach of relevant departments. Some courts have broken through the limitations of trial resources and adopted a 3-in-1 trial mode for civil, criminal, and administrative cases. By centralizing the trial procedures, they have established a leading department for family education guidance, composed of a juvenile division or juvenile judge team, and jointly built a family education guidance service center with members of the family education guidance coordination group to provide teaching venues for participating guidance personnel. They have extensively recruited professional talent such as psychological counselors who are knowledgeable, caring, and have empathy to serve as people's assessors and promote the professionalization of judges' team. They've adopted various flexible means to understand the psychological needs of minors, such as the Lefa mom team, composed of civil, criminal, and administrative trial support staff and people's assessors from the courts in Leshan County. They have used the Lefa mom mailbox to sort of guidance needs and carried out targeted family education guidance lectures to improve family education abilities. They also have opened a Lefa mom micro classroom for legal education, regularly carried out legal information campaigns on the family education column, and cultivated correct family education concepts for guardians. They have expanded scope of family education guidance targets, establish a family liability supervision system, and build a personnel database for family investigator, family mediator, enforcement assistance in combination with problems found in trials. They have included special groups such as the left behind children, single parent families, and people with physical and intellectual challenges in the scope of supervision or guardianship. Well, thirdly, we have established joint cooperation mechanism. The courts across the province have cooperated with government agencies and social organizations to establish family education guidance coordination office, organizing relevant departments to provide professional service, including psychological intervention and judicial assistance, to jointly carry out family education guidance together with the institutions, which initiated requests for family education guidance and to promote orderly connection between the judicial protection and social protection of minors. Some courts have signed the cooperation mechanism for family education guidance for minors with women's federations and other organizations, establishing a sound mechanism for multi-departmental communication and consultation. They also hold regular meetings to conduct research on regular communication and collaboration, strengthening the protection of minors, enhancing family education guidance, and jointly explore different topics such as joint family investigations for minors, case-by-case analysis of the content and methods of family education guidance, determination of the guidance personnel in professional talent pools, and collective education on family education guidance situations, thus promoting the systematic development of family education guidance. Courts also actively cooperate with women's federations, charitable organizations, and others to provide economic financial assistance to minors in difficulty and to provide timely follow-up support. Well, fourthly, we have developed a professional talent pool. Judges are encouraged to proactively carry out family education guidance. Special training has been provided to judges on its application. Besides, according to the opinions on the strengthening the trial of minors in a new era promulgated by the Supreme People's Court, a special performance assessment has been implemented for the trial of minors. Local courts explore the establishment of a mechanism to assess the performance of case handling judges in family education guidance. Such a mechanism takes into consideration social survey and return visit to help and educate in the process of education guidance, formulates detailed formula based upon caseload according to the regional assessment methods, and as assessment of the application rate, standardization and effectiveness of family education guidance so as to alleviate the concerns of judges who are afraid, unwilling, or unable to provide family education guidance. Courts, in the meantime, actively coordinate with the local governments. In the process, professionals are encouraged to form a pool of family education guidance experts through the government's procurement of services. Relevant personnel are randomly selected from and local guidance professionals receive regular training. Relevant personnel are randomly selected from the pool to carry out the guidance, and local guidance professionals receive regular training to improve the quality of their guidance services. At present, the family education guidance system is playing an increasingly important role, but existing rules still separate the right to family education guidance and the right to expert penalties. The supervision of education guidance still lacks strong support. We also recommend legislation which clarifies this institutions initiating the request for family education should have the responsibility to both offer family education guidance and punish legal acts. In addition, it is also recommended that the supporting opinions on family education guidance by people's courts be issued as soon as possible so that we can provide better guidance in family education. I want to thank Judge Sun. Nextly, we shall give the floor to another Judge Sun from the Communist Youth League, who speak on the important topic here. Dear Judge Jiang, dear Kamm, Judge Edwards, I'm very honored to participate in this presentation. This is Judge Liu, sorry. So, the healthy growth of minors is related to the well-being of thousands of families and the future of the country and the nation. Strengthening the protection of minors is a worldwide consensus. China's newly amended law on protection of minors provides for the principle of the best interests of the minors, which is not only a localized expression of the principle of the best interests of the child in the UN Convention on the Rights of the Child, but also a solemn commitment by the Chinese government to the protection of minors and the practical guidance for all sectors of society. As the largest youth organization in China, the All China Youth Federation conscientiously implements its responsibilities under the law of protection of minors and the law on the prevention of juvenile delinquency, and actively participates in the protection of minors, including judicial protection. In January 2023, the Central Committee of the Communist Youth League of China, CYLC, and the National Work Committee of China's Young Pioneers promulgated opinions on strengthening the Chinese Communist Youth League's work on the protection of minors in a new era. Since the Communist Youth League of China is the most important member organization of the All China Youth Federation, the issuance of the document is of great guiding significance for the further implementing the Chinese government's guiding thoughts on the protection of minors and the strengthening of the Communist Youth League's work on such protection in the new era. Specifically regarding judicial protection, we have found in our particular work that the handling of some complex cases of minors involve the minors-related police work, prosecutorial work, the trial and community protection, psychological comfort, return visits to help educate, social integration, other aspects. So it burdened many departments with heavy workloads and the regional professional requirements, making it difficult to accomplish by one agency alone. It's necessary to fully coordinate the efforts of all parties, all agencies to build a social support system for the judicial protection system. From a global perspective, a mature judicial system minors supported by a sound and complete social support system. Lastly, please allow me to introduce to you the All China Youth Federation's work on building strong social support system for the judicial protection of minors in recent years. Firstly, we have strengthened the top-level design. In February 2018, we signed a cooperation framework agreement on building a social support system for juvenile prosecutorial work with the Supreme People's Prosecutorial Office to explore working mechanism for improving the judicial protection of minors, strengthening the protection of the promotion of the rule of law and the crime prevention among young people, and enhancing the protection of minors' rights and interests. Afterwards, in accordance with the approach of the Lead with Palace, Drive with Demonstration, the project was the first pilot in 40 regions and later expanded to 80, achieving positive outcomes so far. Most of the provincial level youth league committees authorities and the prosecutor's authorities have signed similar agreements, and many local youth league organizations have also cooperated with courts and judicial other law enforcement agencies. For example, all 11 county level or prefecture level youth league committees in Hebei province have signed the cooperation agreements with the prosecutor's office at the same level, or the youth league at the Shanxi provincial level in conjunction with the Commission of the Police and Legal Affairs other departments in the province, as well as other judicial departments, to provide strong support. So secondly, we have been building a strong team of social workers. The implementation of judicial protection safety system for minors cannot be achieved without the patient, meticulous, and professional work of social workers responsible for youth affairs. Since 2014, we've been working with the Ministry of Civil Affairs to actively strengthen the building team of social workers for youth affairs. So far, a total of 233,500 social workers of this kind have been trained and contracted by the Youth League organization at all levels, many of whom work in juvenile justice. They are active on front lines on social investigation, psychological counseling, observation protection assistance, education and supervision, inspection of conditional non-prosecution, assisting in the implementation of various judicial protection systems involving minors, delivering special care and warm solutions government to the children. In addition, we have engaged nearly 5,000 legal psychological experts through the 12,355 youth service hotline. 12355 is a phone number. Youth service hotline to provide professional support to judicial protection minors. In one case, where a young boy, after being abused, misbehaved due to physical and mental trauma, all parties then immediately began to help. On the one hand, the judicial authorities punish him for his criminal behavior in accordance with the relevant law. On the other hand, the local social workers for the youth affairs immediately intervene. They managed to comprehensively understand the family social reasons behind the case. They made a weekly home visit to the boy and provided overall support in legal aid, psychological counseling, financial assistance, and other aspects to help him smoothly return to his family and society. So it is through these meticulous efforts that many children and our social workers in youth affairs have built a deep bond and actually end up being good friends. Or thirdly, standardizing the work process. In the process of carrying out our work, we explore the workflow, management methods, and the assessment methods of social workers responsible for youth affairs participation in judicial practice. In fact, last year, together with the Ministry of Civil Affairs and the Supreme People's Prosecutor's Office, we drafted national standard for the specification for judicial social work services for minors, which has now submitted to the relevant authorities for standardization. We have believed that it will enhance the standardization. Also, we have summarized some local experience to adapt the rules to local realities. For example, the Shenzhen City in Guangdong Province has formulated the Shenzhen Standard for Precision Assistant Education, which includes norms for handling juvenile justice, criminal justice cases, performance assessment, measure for juvenile prosecutorial work, etc. The Yongchuan district of Chongqing municipality has refined its standards for 10 tasks such as the social investigation, observation, protection, assistance, and education to improve the professionalism of its work in Guangxi and the Hebei province material working model for prosecutors plus youth league staff and judicial social workers plus volunteers be established. The Chinese President Xi Jinping once pointed out that the judiciary is the last line of defense for social fairness and justice, specifically when it comes to juvenile justice. Strict, timely, and efficient judicial protection is the bottom line that we must be firmly guarded. For next step, we're going to work with relevant agencies, study and formulate opinions on the strengthening social work services in the judicial protection of minors, and actively cooperate with judicial agencies, participate in social governance based on the advantages of the responsibilities of social organization, gradually improve the social support system for the judicial protection of minors, and put the efforts of all parties to protect minors. Thank you so much. I want to thank Ms. Liu Yuanqi's excellent presentation. That concludes the presentation from the Chinese side. Now let's move on to our interactions and Q&A. So hand over the floor to Judge Edwards for you to ask questions and Chinese participant answer.
We are now going to answer questions that each of us posed to our Chinese colleagues and they posed to us. I will start with the question that Judge Fan Yu sent to me, and then I will turn over to Judge Nash, and he will both ask and answer the question that was presented to him, And then our third presenter, Jean Roland, will answer the question that was asked to her. After those three questions have been asked and answered, we will turn the matter over to Judge Jiang again. The question that Judge Fan Yu asked me is as follows. What are the preconditions for unsealing juvenile criminal records in the United States? Will juvenile criminal records be destroyed after they have been sealed for a certain period of time under certain circumstances? Two questions. I will try to answer both. First of all, record sealing laws are different in each of our states. Also, the federal law is different from any of the states. I will discuss California law as it has the best laws for record sealing in the United States. It is possible to unseal a record for specific purposes. For example, if the prosecutor needs to find out if there is evidence that would be exculpatory to the defendant in another case, a current case, he has the right to examine sealed records. If he discovers any exculpatory evidence, he must provide that to the defendant in the current case. He may not disseminate that record other than to use it in the new pending case. If there is a defamation case, the sealed record may be relevant and can be unsealed. Again, the record cannot be further disseminated. If there is a pending family law or probate case involving the juvenile or his or her family, the record may be unsealed and used in those proceedings if the record is relevant. But the use is restricted just to those proceedings. I will answer the second question. Juvenile criminal records will be destroyed automatically, in most cases 5 years after the record was sealed. That's section 871, subsection D. In most other cases, the record shall be destroyed when the juvenile reaches the age of 38. In very serious cases, the records will not automatically be destroyed. However, in those serious cases, the juvenile, who is now an adult, can petition the court to have the record destroyed. At any such hearing, the prosecutor and victim may appear, and the judge will decide if the record will be destroyed. You may refer to the article that I sent to you for our presentation. It is entitled, Record Sealing, Its Importance for Rehabilitation. And now I'm going to turn to Judge Nash for the question and his answer to that question. Judge Nash.
Thank you. I'm now going to answer a question from Judge Sun. The question is, what do judicial organs in the United States do to deal with juvenile cybercrimes or online violations against juveniles? The Office of Juvenile Justice and Delinquency Prevention, commonly known as OJJDP, is located in the United States Department of Justice. Within OJJDP is the Internet Crimes Against Children, ICAC, task force, which helps state and local law enforcement agencies develop responses to technology facilitated child sexual exploitation and internet crimes against children. This program is a response to the increase in the number of children and teenagers using the internet and the growth in the number of child sexual abuse images online, as well as an increase online of activity by predators seeking unsupervised contact with underage victims. In 2021, the ICAC task force conducted more than 137,000 investigations, resulting in more than 10,400 arrests. Juveniles are also perpetrators of cybercrime, including identity theft, hacking, bullying, stalking, and harassment. For example, in California, a person who uses an electronic communication device to harass, intimidate, annoy, or stalk another is subject to criminal charges. Devices include telephones, cell phones, computers, and more. If the perpetrator is under the age of 18, their case will be heard in juvenile court. Another type of crime is known as sexting, which is the taking, receiving, or sending of nude or sexual photos by electronic means, such as a text message, email, or social media. Once again, if the perpetrator is under the age of 18, their case will be heard in juvenile court. I'm now going to turn the screen back over to Judge Edwards.
Thank you. And now, Jean Roland, I believe you have a question and an answer for that question. Go ahead.
Thank you. So I have two questions, and I will address them separately. The first question was, according to the cases you have handled in recent years, what are the new phenomena and problems of local juvenile delinquency? So I do not know if it is a new, but in recent years, there is a strong interest and movement to keep juveniles out of the juvenile system and turn more to local community-based organizations to foster positive rehabilitative efforts with youths. Some of the problems we face when trying to divert youths out of the system are the limitations in resources for specific population of youths. For example, those youths who reside out of our jurisdiction and youths who are unaccompanied minors in our country. The second question is, what are the good experience and practices for preventing juvenile delinquency? So our restorative justice program, which we implemented in 2013, 10 years ago, has shown that engagement between the party harmed and the youth in a positive conference reduces recidivism. Although this may not address preventing juvenile delinquency from the start, it is a key factor in reducing the continuing cycle of crime for many of our youths in the delinquency system. If there was a way to recognize at-risk youth at an earlier age and provide services and resources to the youth and families, that may be a way to further prevent juvenile delinquency. I will turn it back to you, Judge Edwards.
Thank you, Jean Roland. And now, Judge Jiang, I turn this question and answer period over to you and your judges. Thank you.
非常感谢美国同仁对中方
Thank
问
you
题
so
的
much, U.S. colleagues, for answering these important questions. Your explanations and responses have deepened our understanding about the juvenile justice system in the U.S. We will carefully study them and apply them. I would like to now invite the Chinese colleagues to answer U.S. questions. I will take the first three questions. First, in the report to the National People's Congress submitted in March 2023, SPC disclosed that the number convicted minors in Chinese schools decreased from 56,000 in 2013 to 28,000 in 2022. There is remarkable improvement. Could you tell us more about the following things? For example, the age distribution, how many are women, and is the downturn caused by the new policies after the 2013 amendment of the criminal procedures, and how much of the downfall can be attributable to the pandemic control measures? For example, the reduced hearings. This is question one. I will address it. In recent years, the number of the convicted minors on a yearly basis has been trending down from the 56,000 in 2013 to 28,000 in 2022. And the share of the minors in the total convicts is also declining year by year, from 5% in 2013 to 2% in 2022. In terms of the age distribution, more than 85% of the juvenile criminals are between 16 to 17 years old. The females accounted for 7% or so. And the case types or the charges tend to be quite focused. Usually the crimes against property or violent crimes, like the theft, robbery, rape, picking troubles, battery in groups, and other offenses. And the minor convicts tend to be poorly educated. So over 80% of them are educated at the level of a junior high school or below. And these juvenile convicts tend to lack the skills to make a living, lack due jobs or stable sources of revenue. And they're also affected by the internet and the games, and led astray by the negative factors they're in. In terms of the downturn, on one hand, China's improved and amended the criminal procedures and introduced a special chapter of the criminal procedures for the minors as a special procedure. In Article 271.1, it provides that for the juvenile crimes covered in Chapter 4, 5, and 6, if the punishment is 1 year of imprisonment or less, and if there's also regret and repension, the People's Prosecutor may decide to introduce conditional non-prosecution. On the other hand, the Chinese courts are paying close attention to the prevention and adjudication of the juvenile cases. They implement the criminal procedural law and the law on protection of the minors. They educate and rehabilitate the principals and focus on education rather than the punishment. They try their best to help the minor convicts to rehabilitate and return to the right track of life. The courts will also carry out a social survey, care, mental counseling, and legal education, so as to help the minors understand why they commit the crimes and what they did wrong, and promote their sincere repention. And after the conclusion of the cases, the judges will also pool resources from different departments and make follow-on visits and follow-up rehabilitation and prevent reoffense. And most of the minors, after such education, will rehabilitate and return to the society, be law-abiding talents and citizens. The downturn of the minor convicts is the overall trend during the last decade, rather than a new phenomenon arising just after the COVID pandemic. During the 3 years of the fight against COVID, Chinese courts have used online litigation and virtual hearings to ensure the sound progress of the adjudication work. That is my response, the first question. Second one, what social workers have done to reduce the number of children in the group shelters or orphanages. So I would like to also combine this question with a third one, because they are quite similar.
Because the third question, as you know, is the congregate care and the orphans, do they exist in China? If so, how they should be applied? So let me answer these two questions together. So in China, orphans refer to minors under the age of 18 who have lost their parents or whose parents cannot be found. According to the opinions by the General Office of the State Council on Strengthening the Protection of Minors, the local governments at all levels should, in accordance with the principle of the best interest of physical and mental health interest of orphans, take various ways to expand the channels for orphans and properly place orphans. Among them, for severely disabled children who have no relatives or other guardians to raise them after announcement in accordance with the law. The children's welfare institutions established by the civil affairs agencies will take care of those orphans. The child welfare institutions with the better support, financial support, can buy or rent houses in the community or build apartments in the institution and provide family care services for orphans, for healthy children and slightly disabled children. The following means should be implemented to help children return to their homes or relatives so they can have a normal life. One is family support and other laws, regulations. We can try to determine the guidance of the orphans. For example, the grandparents and brothers and sisters of orphans should bear the relevant obligation of raising and perform the duty of guardianship according to the law. Other close relatives and friends are encouraged to act as guardians for the orphans. If there's no such guardians, then the employer of the minor's parents or the residential committee or village committee or the civil affairs departments, namely the government agencies themselves, should act as the guardians. The second one is the family fosterage. So if the guardian is the employer of the parents or the committee of the area where they're often lived, then the guardian can evaluate the family with the willingness and ability to raise, select the family with the better financial conditions to carry out the entrusted guardianship of family fosterage, and the governments shall provide subsidies to those foster families. Also, we encourage the adoption as well. We have the relevant adoption laws. If we have the families who are willing to adopt the orphans, the government agencies shall provide the relevant procedure, provide facilities to facilitate such adoption procedures. Also, we have encouraged the adoption by foreigners as well. We have a roll out the relevant laws to encourage such adoptions as well, but we need to make further rules with regard to the adoption by foreigners. So the Chinese government has always given top priority to the children's welfare work. In 2010, the General Office of the Council issued opinions on strengthening the orphan safety work, which provides the relevant made relevant arrangements for the basic life education, medical care, and employment after adulthood of the orphans. The Chinese welfare facilities have been generally improved, and the healthcare level of the orphans have been improved as well. Also, the recent year, we have greatly improved the basic living standards for the orphans, including orphans and other special children groups in the scope of temporary agencies. We have promoted the linkage between the safety standards as well as the relevant living standards. So in response to the needs of the medical rehabilitation and education for orphans, we vigorously promoted the work for medical assistance for the orphans. We have invested 1.7 billion RMB in the welfare lottery public affairs fund system to provide rehabilitation treatment for sick and disabled orphans. So every year, nearly 300 million yuan of public welfare fund is arranged to subsidize orphans to study in universities or specialized secondary schools. In 2021, the Ministry of Civil Affairs and other 14 government agencies promulgated opinions on the further promoting the optimization and the quality improvement of children welfare institutions and high quality development of innovative transformation, and promote the integrated development of child care, medical care, rehabilitation, education, social work of child welfare institutions, and further improve the professional level of orphan protection and precise management. So I would like to hand over the floor to my colleague, Judge Fan, for the first question. The first question is proposed by Judge Roland. So which goes like if a minor commits a very serious offense, is allowed by the Chinese law to be transferred to the adult criminal justice system. If minors are prosecuted in the adult criminal justice system, is there an age limit? In California, only 16 and 17-year-olds can be transferred to the adult criminal justice system. In Chinese law, how old do minors need to be before they can be prosecuted? So let me address this question. According to the Article 550 of the Judicial Interpretation of the Criminal Procedural Law, in cases where defendant is less than 18 years old when he committed the alleged crime or offense, and less than 20 years old when the case is filed by the court or trial by the juvenile court, the Chinese court system will set up a specialized agency, this designated special personnel to hear the juvenile cases. Like I mentioned, that we have this 3-in-1 system combining civil, criminal, and administrative. So there's the specialized court panel which handles such cases. So even if the minors commit a very serious offense, he or she shall not be transferred to criminal justice directly. So even the law provides that even for the conspiracy crimes, when the conspirators, accomplice or conspirators are minors, we also have the law which is clear that we need to have a specialized panel. Even though the law says that the president of a court can decide if the minors will be tried by a normal criminal justice court, in reality, the president will always assign the minors to the special panel, special judges. So for the age limit, we have the different rules. For example, according to Article 17 of the Penal Code, if someone is already 16 years old, he should be fully criminal liable. If someone is between 14 to 16 years old, if he or she commits the violent crimes like murder, intentional assault, causing serious injury or death, or rape, robbery, sale of drugs, arson, explosion, or putting poisons, then he should be criminal liable. Well, between those between 12 years old to less than 14 years old who has committed serious crime offenses like murder, intentional assault, causing death, etc., but with very cruel means, then with the approval of the Supreme People's Prosecutors, then this 12 to 14-year-old defendant can also be held criminal liable. Therefore, as you can see in the law, the age limit is 16. Anyone beyond 16 can be completely criminally charged and convicted. Between 14 to 16, only the 8 category special violent crimes will be prosecuted and convicted. But between 12 to 14, there are more strict requirements, only, again, for very violent crimes causing death, serious injury with very cruel means, but also this only be prosecuted with the approval of the Supreme People's Prosecutors. Then he or she can be criminally liable. So therefore, there's a question within Chinese law that minors have to be at least 12 years old and also meet those very strict requirements before he can be criminally prosecuted. I want to thank my colleagues. I think we have answered all the questions from our US side. I'll hand the floor back to Judge Edwards.
Well, thank you for those very interesting comments and answers to our questions. I can see that the Chinese juvenile system is very sophisticated and has been addressing the same issues that we address here in California and the United States. It's been an honor to participate in this exchange of ideas. Once again, we've learned from our Chinese colleagues, and I hope that you have learned from your colleagues here in the United States. And now I'm going to thank the panelists from the United States, Judge Nash, Jean Roland, and turn the hearing over to John Kamm. John.
Well, thank you, Judge Edwards. You know, we have had several valuable exchanges with our friends in China, but in my opinion, I think this is the best. Why do I say that? Well, for one reason, when we started this program, until now, almost 2 hours, not a single attendee has dropped out. Now think of that. Everyone is still attending after almost 2 hours, not quite, which is really quite extraordinary. And so I'm very grateful. So I would like to thank my old friend, Deputy Director General Judge Jiang, the Chinese participants and presenters, and all of the Americans for their valuable contributions. So thank you very much. And now I will turn it over to my dear friend, Judge Jiang.
Old friend, Executive Director John Kamm. I want to thank Judge Edwards and other U.S. colleagues. Your very insightful presentation and answers are very useful, beneficial to us. Also, I want to thank my colleagues at the International Cooperation Department, my other colleagues, as well as the interpreters. Also, I want to Judge Sun, Judge Fan, and Ms. Liu for the panelists for their participation. I think our webinar has been very successful. Lots of sophisticated mechanisms of both countries have been exchanged, and we can draw on from each other through this discussion. We can accomplish our intended goals. Also, I hope that going forward, two countries can have a further in-depth exchange when it comes to juvenile justice and have more cooperation on this important topic. I hope next year we can have an in-person discussion. We can meet each other in person, so we can strengthen our cooperation. I very much look forward to in-person dialogues next year. Thank you so much, Executive Director Kamm.